Okay. Thank you very much, Eka, and thank you very much for having me today. Let's see. Let me just get my notes in order real quick. Okay. Yeah, thanks again for having me. Thanks for organizing, and thanks also for all the work that you've been doing so far. I would like to, as Elka mentioned, provide you a little bit of an outlook, hopefully, to the Data Access Portal. This is kind of the basic topic for today. I would like to be as concrete and practical as I can, but I also want to be honest and say that there are still open questions, lots of them, and I would also try to touch upon those. So as I said, Data Access Portal maybe as the main part. I will also do a little bit of a backwards and forwards look. For this, my name is Julian. I work at the German DSC. As mentioned, I was at SNV before Interface, so I followed the DSA and data access topics quite a lot, but maybe it's also important for you to know as researchers here, I myself don't work with data. I don't have those skills, but I followed it from the policy side more. But I know that a lot of people here in the room have worked with data before, and I don't want to go back the decades that you've been working on this, but just a very brief snapshot. So like 2019 is, I think, when the DSA debate started. 2022 is when it took effect, and only these past 2 years, 24, 25, the Delegated Act was really the focus, is now being finalized, is now coming into effect. But of course, I know that many people in this room, you have been very busy. You have not been sitting idly by. As I said, you've been working on this for quite some time. We've heard about proposals for data structure. We've heard about trying to work with 4012 data already. We've heard about the networking and the collaboration that's been going on. And so maybe for me to know who here has tried to work with 4012 data. Show of hands. So that's a decent amount. Who here would like to work with 44 data? So what I'm talking about now. Also quite a lot of people. Great. So I think I can address you directly in this presentation. That's kind of the background to this question. But at the same time, the regulators have also been busy preparing internally, consulting internally, having external public consultations on the Delegated Act, as we mentioned. Lots of internal preparation concerning legal questions, data protection questions. And so now we're at this point where hopefully very soon, next month, we can actually see this in practice and use these opportunities that hopefully the Delegated Act and Data Access under 44 will bring. Allow me this one cheesy, a little bit cliche phrase that I'm going to use now. There will be lots of opportunities, but these opportunities will be based on limitations. So we will have limitations to create new opportunities. Again, sorry, a little bit cliche, but some of the limitations you already know, and I just want to highlight 3 of them. For that data access that I'm talking about right now, you can only have that once you, as a researcher, as a research team, have been vetted by a DSC with a fairly demanding set of, especially privacy-related, data protection-related prerequisites that you have to fulfill. It's only research that concerns VLOBs, and it's only research that concerns systemic risk and risk mitigation in the EU. Arguably, this is the opportunities part of it. I would still say this is better than the system that we have right now, which is basically corporate-led, voluntary, ad hoc, do I know this person at the platform type data access. So hopefully these opportunities will materialize, and they will hopefully materialize with a tool or a software, a portal that's called the Data Access Portal, the DSA Data Access Portal, which is what I want to talk about today a little bit. It's already live in a test version. If you haven't registered for it or haven't signed up for it, I would encourage you to do so, just so you get a feel for it. And this will be the main avenue to go through for data access. And this is what I would like to focus on. But before I do that, I do have to give you this disclaimer. What I'm about to say is not legal advice. It's still subject to change. As I said, it's a better version of this data access portal. It can still change, and all of the examples that I give or the practical hints, unfortunately, are not like set in stone. Okay, but with that, let's get to it. And I want to start with mapping the data access portal pages to the DSA and the Delegated Act, just so you have an overview. So on the left-hand side, you see the pages of the Data Access Portal. In the middle, you see the topics, and on the right-hand side, you see the DSA articles and the Delegated Act articles. And what I just want to show with this is the portal very neatly maps with the Delegated Act. So if you've already looked at the Delegated Act, you will very much see that reflected in the Data Access Portal. And what you also see on this page, the first page of the Data Access Portal is about the researchers, but then the second page of the portal, that's really a key part. That's where you talk about your research, that's where you talk about your data protection measures, that's where you talk about your data security measures. And so this will be a big part of the presentation. There are more pages to the Data Access Portal. I will also go into those. There's a summary in your choice of DSC. I will also touch upon that. But let's start with the first page. The first page is really about providing an overview of the people behind the application. So the researchers, the research team. And maybe the first important point here to note is that every researcher needs to have an EU login account. That's an account that the Commission provides. Everyone needs that. The principal researcher needs to invite any other researchers to the application. Only once every single team member is part of the application can the application be submitted. And as far as I understand it, team members can be removed from the team, but they can be added on later. So it's really important to get the team together in the beginning. Now, this first page on the researchers has two big parts. One is about the researchers' affiliation, and the other part is about the researchers' independence. There's a mandatory upload field to provide evidence regarding the organization and its affiliation, and there's an optional upload field for the documents regarding the independence of the organization. I think it's safe to say that it can be recommended to also upload documents regarding the independence. It's maybe also important to say that you can upload multiple documents. So the bottom line of this first page, I would say, is that researchers should provide as much evidence as they can that one, the research organization is, the research is the primary goal of this organization, and two, that the organization does not have commercial interest, or if it does have commercial interest, they are used to reinvest in research. You can also, of course, say that you're a public organization such as a university. And that three, that there is no company or other third party with commercial interest that, for example, gets preferential access to the data. So this is the kind of evidence that I think is necessary here, and potential examples, just as, potential ideas here are to show this: work contracts, financial commitments. Maybe your organization has a statute where it clearly states the research purpose. Maybe there's even a law, in case of universities. Proof of membership in academic associations. Those are potentially some documents that might be helpful here. Now onto this big second page, which starts with funding. And here, the bottom line, the overarching goal is to show the source, the amount, and the duration of the money that funds your research. It is important to maybe also provide some examples of non-financial contributions that organizations might receive: infrastructure, software. It would also be important to maybe explain if the funding runs out at some point and the entire research is not covered, explain how the rest of the research is funded and covered. And you can do that in this optional supporting evidence. Other evidence that might be potentially considered here is maybe there's signed letters from funders, maybe there's written financial commitments that could be submitted. These would be some of the documents that could be provided here. The next part of the second page is the research topic, the data that you need, the questions that you're trying to answer. And I feel like this is one of the parts of the application where regulators or me personally can't really provide much feedback or input in, because it's really about your research. It's about your methodology, the data that you need, the research questions that you have. There is a non-exhaustive list of potential data in the Delegated Act. I think it's recital 13. At some point, the VLOBs will also have data catalogs that can be used. Maybe one or two important points that I can highlight is there's one application per VLAN. So even if you have a research question that you want to address to multiple platforms and companies, you have to turn in for every company. And it's also important reminder that detailed descriptions about the systemic risk or the risk mitigation methods that you're trying to study are really crucial. And this also important to note that the data access is for a specific purpose, for a specific amount of time. So also be clear about as clear as you can about that. Okay. The next big chunk of this already goes into the data protection, privacy protection, data security part of the application. And the first part that is being asked about here is necessity and proportionality. Here, I would say the main part is, or the key questions that you can think about is trying to prove or trying to provide evidence that your research setup considers the rights of the users and the legitimate interests of the company. So some of the key questions maybe to be considered is, can I do this research with other data, with less data, maybe with non-personal data? And if I can't do the research with that, why is that? So good explanations of anonymization questions that you might have come up in your research, and good descriptions or considerations regarding data minimization. This is what you can provide on this page. Just on a technical side, it's important to say that at the bottom of page 2 of the application, there's one upload field for all of the stuff that I'm talking about now regarding necessity, data protection, data security. And you can upload as many documents or multiple documents to provide these things. And some of the potential examples to deal with necessity and proportionality, a data management plan or a data protection impact assessment. If you don't have that, for example, if you don't have a data protection impact assessment, maybe you can upload a document stating why you don't have that, why it might not be necessary in this case, or what constraints there are that you don't have. So I guess here also, again, the reminder, try to be as transparent as possible about the setup of your research. As mentioned, data protection itself is one of the key parts, and this is where page 2 then hits on data protection. Maybe a quick note, especially for the German context, in some member states, and Germany is one of them, the data protection authorities have a key say in reviewing the application, at least for the data protection part. So just to give you a concrete example from Germany, the German DSC, where I work, we will be receiving applications potentially, but for the data protection part, our German data protection authorities, they will actually be the one helping us reviewing the applications. And so what the DSC, so what the data protection authorities would need to see or would like to see is a good detailed description of data use from start to finish. Data collection, data storage, data retention or deletion, that's kind of the whole cycle of data use, how that's being handled in the research project. This is what you can input here. And I mentioned that before, the question about data minimization and data anonymization can also pop up here. Maybe one quick note about this term that you might have seen in the Access Portal, like legal grounds or processing grounds, legal basis for the applications. We've heard about it before. GDPR has that opening, and Article 40 of the DSA is the very basis for the processing grounds or for the application itself. But what they're asking about here is the specific GDPR due diligence that is necessary for the actual data use. So not for the application, but for the data use that you have. And so once again, potential examples for documents, a data management plan as mentioned, a data protection impact assessment as mentioned. Maybe your organization has policies regarding data retention, regarding, if necessary, international data transfers. Maybe some of the team members have certificates regarding data protection or privacy preserving practices. So this would all be could potentially be documents that could be turned in here. Even if researchers don't use personal data or don't need personal data for their research, this is still a part of the second page that needs to be considered and filled out, data security and confidentiality. This is really about asking confidentiality regarding the company's trade secrets and considering that angle in the setup of your research. So I think in the actual application is called technical and organizational measures, and some of the potential documents that might come into play here, policies that you might have on information security, on activity logging. Maybe you can explain the physical infrastructure of your research facilities. Maybe you have policies against hacking. Maybe bigger organizations have follow ISO standards. I think it's ISO standard 27001 and 27002 that talk about information security. If you have that, this would be certification that you could upload here. And once again, you saw that in all the previous slides, it's all to be uploaded at the bottom of page 2, where you can upload all these documents. The last part of the second page in the application is the publication, where researchers have to tick a box to commit to publish the research free of charge and input a date. You can upload a document either on page 2 or at the very last page. For example, if you have a funding commitment for the publication, or if you have a funding or a publication timeline, this is something that could potentially be additional evidence here. And now we're leaving that gigantic page 2 and coming more towards the end of it, where you have to provide a summary of the research and of the application, which will be published by the DSCs according to the Delegated Act. But then what I really want to talk about real quick is the choice of DSC. And I'm fairly certain most of you know this, so you can choose whether to turn in this application to the DSC where the VLOP is based, that the research concerns, or where the principal research organization is based. And this would be the choice screen where you do that in the end. So as a concrete example, for us in Germany, most likely this will mean that we might receive a lot of applications, but in many cases we expect to forward them to other DSCs, namely our Irish colleagues, because I don't think I need to remind you, most of the VLOPs are based in Ireland. But the flip side of that, if we ever get a research request regarding Zalando, this will be completely done by us. Is there anyone already looking at research Zalando? Okay, so this would be a vetting decision that would be in the German DSC's hands from start to finish. And this is kind of my segue to the second part of this presentation. Everything I talked about now, this is a lot of work for the researchers, right? Like, you have to deal with all of that. Once the application is turned in, this is where the DSCs obviously come in and all our work starts, and especially the Irish colleagues' work starts. So depending on the DSC that the researchers have chosen, that's when the whole application process then goes into their hands, and there's a couple of steps taken where the data access portal is connected to what's called Agora. Agora is this secure information sharing communication system that all the DSCs and the Commission have. And once we have received the application through the data access portal in this Agora system, there are multiple steps that DSCs have to take in order to look at the application. The very first step being a completeness check. As the name suggests, it's really just checking completeness. Are all the documents there? Is it not just, lorem ipsum text in the fields? But then the next part is the actual first assessment that DSCs have to do. That can happen without an expert consultation or with an expert consultation. I will skip that for now and leave that out. I will also skip the potential mediation. That's another set of processes, but I will skip that for today. After this initial assessment is the final assessment, which is really this then additional in-depth look at the application, and it leads to a reasoned request. And this reasoned request, as again most of you probably know already, is a kind of note from the DSC to the VLOP, to the data provider, based on the application and based on the DSC's comments, after which hopefully the data can be provided. Now you see all these steps, and I want to try to give you a little bit of insight what that actually means for us at the DSC, how we deal with this, like how we try to prepare for this. Because it is a lot of preparatory work that my colleagues are doing and that I try to support them with. It's about figuring out what type of workflows we need internally and across units. sounds pretty lame and boring, but it's actually something that we have to consider, getting legal experts from one unit, technical experts from another unit, and kind of, I guess, outreach expertise, people who kind of know the national research landscape from another unit, getting them together. In addition to that, coordinating with the data protection authorities who, as I mentioned, in Germany have a important legal role for us to play. And then on top of that, of course, being able to very diligently and legally compliant document all our actions, because we're a public authority. So for all of these steps, these preparatory steps, once we have the application, there are then deadlines, as you can see on the slide. And the expectation is that at least for the first applications, these maximum days will most likely be used. It's a fairly new process. As I said, there's a lot of stuff to figure out, and I wouldn't expect that to be done, like the formulation of a reason request to be done within a week or two. So, if you then calculate maybe early next year at some point, January, February, if it all goes well, we would have the reason requests. With that being said, I'm already getting to this outlook part, like where are we going with this? And of course, we also try to discuss and consider internally, like, what can go wrong, what has to go right. And we have, on this slide, put a couple of scenarios, which I won't go through all of them. But of course, we want to be more here on this right-hand side, where maybe, it takes some time. It does take those 80 days. Maybe we also get a lot of application, which I guess is a good problem to have. And, that kind of overloads the system, at least early on. But as I said, not want to go through all of them, but maybe just that big box there in the middle, because it kind of circles back to the beginning of the presentation. The fact that this system, this process is demanding, especially when it comes to data protection and privacy and confidentiality consideration, and that can be discouraging. We are aware of that. So this is something that I think we have to always keep considering and deal with. Unfortunately, and this already came up today multiple times, at this particular moment in time, we also have to consider potential political backlash. We have to, unfortunately, consider threats against researchers. We have to consider that maybe some platforms are more cooperative than others. But we also, of course, try to figure out how to deal with that. And we don't have answers for all of these open questions. That's why you see some empty boxes. But I do think that events like these, where we get together and talk through issues, where we discuss open questions, where we build networks, where we think about collaborating in the future, that's important. Getting more people involved in this, both at the regulator side when it comes to resources, but also at the researcher side, is really important. And of course, guidance in writing via events will be a big thing, hopefully, for us to help with these potential hurdles as well. And with that, I want to end and invite you to another, maybe more in-depth even, point to further this type of networking and collaborating and guidance giving and seeking. We have a webinar with our Austrian colleagues on October 13th. The Berlin Data Protection Authority will also be there, which is great because they actually know GDPR way better than I do. So if you have questions, this would be the event to go to. If you haven't received an invitation or signed up yet, please feel free to reach out, use this email address, or come talk to me afterwards. And with that, I want to close and really thank you once again, not just for listening today, but also for all the work that you have been doing already and that I hope you will be able to do in the future with the Data Access Portal. Thank you very much.